Welcome to Disability Law for Railroad Workers.
Hey everyone, welcome back to an all-new episode of Disability Law for Railroad Workers. I'm your host, Mike Leon, and today we have a special guest filling in for Roger, his colleague Derrick A. Pearce, a litigation attorney with more than 30 years of experience handling insurance-related matters in Missouri and Kansas. Derrick has tried more than 50 jury trials and regularly represents clients with disability claims that are brought under the Employment Retirement Income Security Act, better known as ERISA. Today's episode, we're going to unpack what ERISA means, why these cases can be so challenging, and how workers can protect their rights out there when an employer or insurance company denies their benefits. Derrick, it's good to see you. Let's start off at the high level here. I just gave the acronym, but what is the Employment Retirement Income Security Act? How does it apply, to employees who have disability coverage through their workplace?
Well, first of all, thank you, Mike, for having me on. It's a pleasure to be here. The Employee Retirement Income Security Act, or ERISA as it's called, it's a federal law that sets the rules for employer-sponsored benefits, including short-term and long-term disability. So many people are offered benefits through their employment in addition to just regular compensation, such as health insurance and life insurance and other benefits. These benefit packages also commonly include disability insurance, which is intended to provide partial income replacement to you if you become sick or injured and unable to perform your job duties. ERISA usually governs how claims decisions are made, how they're reviewed, what your rights are to appeal a decision, or your right to go to court. So ERISA rules are very complicated, and if they're not carefully followed, they can result in a denial even though you have a valid claim.
You know, Derrick, I often get these confused. So maybe you can explain about Social Security disability, because I'm sure a lot of people have heard of SSDI, but not ERISA. What's the key differences between the ERISA disability claim and a government-run program like SSDI?
Well, there are some similarities between SSDI and ERISA. Both are programs that are designed to provide income for people whose health doesn't permit them to work all the way to their normal retirement age, but there are some differences. SSDI is a government program with its own standards and hearings. On the other hand, ERISA claims are usually against a private insurer or plan administrator under an employer's plan, and disputes under ERISA are resolved under its own rules and not the government rules. And these decisions are usually made on paper, and disputes are resolved without formal hearings before an administrative law judge. So those are some key differences. Another difference is the initial eligibility requirements. In an SSDI claim, you generally have to prove that your health problems prevent you from engaging in any substantial gainful activity. And in most cases, that means that if you're capable of working full-time in some capacity, you're not considered to be disabled. But under most ERISA plans, at least initially, you only have to prove that your health problems prevent you from performing the duties of your own occupation. And although this eligibility requirement generally changes after 2 years, at least initially, it is sometimes easier to be approved for an ERISA claim than it is for a Social Security disability claim.
So then what kind of employees are typically covered under ERISA? Is it private sector workers, union employees? What kind of benefit plans as well?
Well, it's not really a question of what kinds of employees are covered under ERISA, but what kind of employers and the type of plan that the employer sponsors. For example, ERISA does not apply to disability plans sponsored by government employers. If you work for a state or local government, for example, your benefit plan is not governed or covered by ERISA. The same is true for plans sponsored by religious institutions such as churches or synagogues. However, if your employer is not a government body or a church and it sponsors a group plan for its employees, there's a really good chance that it's governed by ERISA. It's also probably important to mention here, Mike, that most disability benefit claims are actually handled by an insurance company and not the employer. And in most cases, the employer outsources claim investigations and decisions to an insurance company who also commonly insures the plan and actually pays the benefits. So When you file a claim for disability insurance under your employer's plan, you'll usually be dealing directly with an insurance company and not your actual employer, which is sometimes confusing for people.
Yeah, well, you fed into the follow up perfectly, and let's talk about the insurance company. So, someone files now this disability claim under ERISA. The insurance company denies it. What happens next?
Well, that's a really important question, and it's a great example of why following ERISA is so important. So, when a disability claim is denied, the insurance company it has to explain in writing why the claim was denied and give you a chance to submit an appeal of that decision. And in most cases, you only have 180 days or 6 months to submit that appeal to the insurance company. These appeals are very important because they give you a chance to fill in any holes or gaps in the evidence and address the reasons why the insurance company, the reasons that they gave for their denial. However, what's important about this is that 180-day period is fatal if you miss it. Appeals submitted after the 180-day deadline, or whatever the deadline is in the denial letter, will not be considered by the insurance company. And if you waive your right to submit that appeal or don't submit it on time, you also jeopardize your right to go to court later.
So, Derek, let me ask you, why is the administrative record in all of this so critical? And what must be included before the deadline?
Well, once an insurance company receives an application for disability benefits, they have to begin maintaining a claim file, which is really everything that you submit to the insurance company, all of the medical records the insurance company collects, all the reviews it performs, and all of the decisions that it makes has to be in that claim file. It is literally a record of everything that the insurance company considers in deciding your claim. So the administrative record, which is the claim file basically, is important for a number of reasons. One is that if a claim is denied, as I mentioned earlier, the insurance company has to share the claim file with you free of charge. And then in reviewing the claim file, you give yourself an opportunity to determine whether there's support for the reasons given by the insurance company when they denied your claim. For example, if the insurance company says that there's a gap in your treatment, but the claim file shows that they had medical records that shows that you did receive treatment during that gap, you can use the claim file to point out to the insurance company that they overlooked something when they denied your claim. Also, sometimes people discover after getting the claim file that the insurance company didn't bother to go get any medical records, or they asked for medical records from the wrong provider. This opportunity after the denial to get a copy of your claim file is extremely important so you know what's in it, but there's no way of knowing what's in the administrative record unless you demand to see your claim file. Also, if you have exhausted your appeal, you've submitted your appeal and it's time to go to court, that's your only remaining remedy, the administrative record is likely the only evidence that the court's going to consider. So in most cases, no new or additional evidence is going to be considered. So if you want the court to consider something, it better be in the administrative record. And the only way of knowing if it's in there is to demand a copy of it.
Derek, in your experience, what are some common mistakes you've seen claimants make, or even maybe their doctors make when they're preparing or appealing these ERISA disability claims?
One common mistake unrepresented claimants make is being tricked into submitting an appeal when you're not ready. So many insurance companies will provide a one-page form along with their denial letter and tell you that you can appeal the decision by simply completing and submitting that one-page form. They make it sound so easy, but that's a terrible idea to do that. Good appeals are multiple pages in length and can include hundreds of pages of medical records and exhibits. A one-page form is not nearly sufficient for a good appeal. And remember, once you submit an appeal, you're typically done. You generally only get one bite at the apple in the appeals process. You almost always have 180 days to gather all that evidence that you need and formulate your arguments, and claimants should always take advantage of that time. Another common mistake happens when claimants and their doctors focus more on a medical diagnosis than on functional limitations. For example, some claimants automatically assume that if they have a particular diagnosis, that alone is proof of their disability. That's not true. insurance companies focus on functional limitations a lot more than a diagnosis. So it's really important for claimants and their doctors to explain how a certain diagnosis translates into functional limitations. It's not for example, if you have a bulging disc, it's not the diagnosis of a bulging disc that creates disability, it's the symptoms that it causes. So for a bulging disc, it would be important for the claimant to explain that the condition causes pain or tingling or numbness, which makes it difficult to sit or stand or walk or bend. Because insurance companies are looking for evidence that you were unable to perform your job duties, you also have to explain how your diagnosis and your symptoms impair your ability to function and perform these job duties. And generally, it's just not enough for your doctor to simply send in chart notes to the insurance company. They're looking for targeted opinions about how your conditions specifically prevent you from performing specific job functions. Really, the most common mistake I see, Mike, is one that people don't even realize that they're making. Most people assume that they still have to be employed by the company that provides the disability benefit in order to make a claim for benefits. While that might be true for some things like health insurance, it's not true when it comes to disability insurance. What is important in determining whether someone is eligible for disability benefits is whether they became disabled while they were still employed and covered under the disability plan. We have represented lots of people who did not know that they could apply for disability benefits after their employment ended. Again, what matters is that you become unable to perform your job duties while you were still employed, not whether you filed a claim while you were still employed.
Right. That is good to know. And let's move into the court process of this, because these cases often move into court. What does that process look like? How does it differ from a traditional trial?
A lawsuit under ERISA bears very little resemblance to what we normally think of as a lawsuit. Now, federal litigation typically involves an exchange of information through discovery, like depositions, interviews of witnesses, gathering additional evidence, followed by a full-blown jury trial. But because ERISA evidence is usually confined to that administrative record we were talking about, which is the evidence in your claim file at the time the final decision was made, there's typically no discovery in ERISA cases at all. Also, when we think of traditional litigation, we think of, being able to testify, to tell your side of the story in court, and to right to, like I said, a jury trial. ERISA unfortunately takes away most of these rights. In an ERISA lawsuit, cases are typically decided by a judge after reviewing the administrative record and reading briefs submitted by each side. And generally, there's no trial, just a ruling based on written submissions to the court. So an ERISA lawsuit looks very, very different from other kinds of lawsuits.
Derrick, you've handled so many of these cases. Have you seen any patterns in how insurers evaluate or deny claims?
Unfortunately, I have. Not all, but many insurance companies deliberately design the claims process in such a way to be as annoying and frustrating as possible. They'll repeatedly ask for the same information after you've already supplied it to them. They'll send you letters by regular mail instead of email to deliberately shorten the time you have to respond to a request. They'll process your phone calls through a customer service number where you have to go through 10 or 12 prompts just to speak to a live person. The idea here, I think, is to make the process so frustrating that you'll become discouraged and just quit trying. And if you make it to the decision stage, oftentimes they'll simply automatically deny the claim, almost daring you to go forward, hoping that you will not want to go through the appeals and claims process again and just simply give up. And unfortunately, many claimants do get discouraged. They don't retain legal help and they just quit. And that's exactly what the insurance company wants. It's also something I've noticed that's more and more insurance companies are doing is they are relying on paper reviewers. So these are mostly moonlighting doctors who review medical records on the side for an insurance company, and they render opinions about you without ever seeing you. So all too often, insurance companies will resolve differences and make claim decisions and differences between your actual doctor and their paper reviewer by siding with the paper reviewer who's never seen you.
That is very interesting. So I want to ask you as we land the plane here on this episode, for the listener out there, maybe they are facing a denied claim or they've had a denied claim. What's the single most important thing they should do to protect their rights under ERISA?
Well, this probably sounds a little self-serving, but the single most important thing they can do is talk to an attorney. If your claim has been denied, remember that that clock to submit your appeal is ticking. You need to know what you have to do and when you have to do it if you want to protect your right to contest that denial. You may not necessarily decide that you want an attorney to prepare the appeal for you, but you should at least obtain some legal advice about what ERISA requires and how to preserve your rights. For people who do decide to move forward with it without an attorney, I would tell them to treat the appeal like it's your trial. Calendar the deadline, get a targeted functional capacity opinion, and fill the claim file with everything that you would want a judge to see.
Yeah. Derrick, thank you for the time and insights on this today. We truly appreciate it.
Thank you. Appreciate you having me.
And thank you to everybody out there listening to today's episode of Disability Law for Railroad Workers. Special thanks to Derrick for joining us today. If your disability benefits were denied under your employer's insurance plan, or you'd like to learn more about your rights under ERISA, do me a favor, visit BurnettDriscoll.com today to connect with Derrick and the team. Don't forget to like, review, leave a comment, or share this episode with someone who needs to hear it. As always, I'm Mike Leon. We will see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.